very pleased to be here today with my colleague, Lisa Koblin. Lisa and I presented the firm's first webinar on COVID-19 in early March 2020, the day that it was declared a pandemic, and it has not stopped since then. How quickly things have changed. Next slide, please. Here's what we're going to try to do today. Touch base on mandate issues up top overall, talk extensively about the executive order on government contractors, touch on what we think is going to be in the new OSHA rule, which could be sooner than any of us really anticipate, and then get into vaccine mandates, the pros and not so much the pros and cons, the factors you need to consider in your programs, whether you're trying to comply with government orders or do it on your own, implementation and practical issues, and then that all a very popular issue of disability and particularly religious exemptions. Next slide, please. So we're often asked, how do we prioritize all the stuff that's thrown at you? And this slide is our little checklist on really how to, at the 30,000-foot level, prioritize what it is that you need to follow. The law and the science always start with your executive orders, your local orders, the federal laws, they come first. And following the science, it's always back to the CDC. The CDC guidance, even if it seems outdated, is still considered best practices. It's followed, and then whatever your local health officials say, if they are supplementing that. But in a time when virtually all public health officials have removed most or many of their requirements, the CDC guidance is still your best practices. And in some cases, that's been incorporated into EEOC guidance, so it actually becomes law, and we're going to be giving some examples of that. Then the EEOC guidance in particular, and when I say by guidance, it's the technical assistance that just got updated the other day, as well as older EEOC guidance on the same issues under the ADA and Title VII. And just because it's such a common question, it continues to be the case that your workers' comp liability issues on all of these issues are relatively low risk. It is very, very hard as a practical matter to prove that a workplace claim came or COVID-19 was contracted in the workplace. And even if it is, in every state that we have heard about, it would be covered exclusively by workers' compensation and not by state tort claims. Next slide, please. Big picture, it's amazing to think that 6 months ago, we were still cautioning against any kind of vaccine mandates or to take your time because all the vaccines were still under emergency use authorization. And of course, 5 months ago, those of us who were vaccinated were taking off our masks because we were told, however briefly, we could do that and how quickly that changed. The discussion of mandates and the whole idea of vaccine mandates had evolved very quickly over the summer. First, it was the colleges and universities who were moving for mandates for students and in many cases employees in advance of the fall semester. Then federal agencies started imposing individual mandates. And of course, suddenly, or it seemed very quickly, the Biden administration came down with its executive orders for both federal government contractors and announced that there would be one on a new OSHA rule. So very quickly, many employers have pivoted to, if they weren't thinking about mandates before, they are now, either in anticipation of these regulations or for their own safety protocols as part of return to office or reopening of offices, or for those facilities that have already been opened because of safety concerns. And the focus has shifted to the practical issues. And we are painfully aware from many of our clients in this era of the Great Resignation and staff shortages or the Great Reshuffling, depending on your metaphor, about the trade-off. If I institute mandates, can I afford to lose those people? If I'm complying with mandates, how am I going to deal with the people who just refuse to comply? Next slide. So when we talk about mandates, we found it helpful to think about two different kinds of mandates. The first is what I truly we call a hard or a CAP-M mandate, where full vaccination is a condition of employment absent a religious or medical exemption. if you don't get this, if you are not vaccinated and you don't have an exemption, you will be fired. A softer mandate is where the vaccination is a condition of something. It may be a condition of coming into the office. It may be a condition of you may impose consequences such as testing, but usually this is consequences less than termination. Now, under federal, state, and local laws, as a general rule, unless there is a specific state law otherwise, and we'll be talking a little bit about some of those state laws, you can limit vaccine requirements to certain positions or activities. It's not an all or nothing decision. And so many employers are considering vaccine mandates or other restrictions, a hard or soft mandate for some positions, for some locations, for customer-facing issues, and not for others. Many other companies are saying it's easier and simpler and fairer just to mandate across the board for everyone, even remote workers. Next slide. So to give you some examples, the federal contractor rule is very clearly a hard mandate, and we're going to go into those details in just a second. Unless there is an exemption, federal government, federal employees, federal contractors will be excluded from contracts, and in many cases, that will mean that they are going to lose their jobs. The executive order for larger companies that Lisa will be touching on, this is the new OSHA rule that is at OMB right now, appears to be, based on the executive order, a soft mandate that you will be required as a larger employer to either have your employees vaccinated or to do mandatory weekly testing. But as we'll explore in our questions, there are a lot of questions about that. Next slide, please. So general rules, employers can mandate. That's the most common question we were getting throughout the last year. There's a long history of mandatory vaccinations in the United States. Those of you who've been doing your history or your reading know that some of the first vaccine mandates were in General Washington's army during the Revolutionary War for smallpox. There's a long history of it. There's a lot of law that dates back to the pandemic of 1919. And there's a wide history of required vaccinations for all kinds of industries. By and large, you tend to see this in the healthcare industry. All of you are familiar with mandatory vaccinations required for public schools and the exemptions that have a long history in this country. The U.S. military, any of you who have served know how many shots you were given. Sometimes you didn't know what you were getting. But there are a lot of states who are considering, and some who have passed restrictions on employers, and we'll be touching base on a couple of those. There's still one state, Montana, that has made being unvaccinated a protected class. Last year, there was legislation proposed in virtually every state that would limit or require vaccinations by various employers. And we are seeing a wide variety of mandates already at the state level or local level for different groups, organizations, entities, such as the Illinois requirements on higher education and secondary schools. But by and large, you have the right to impose these, just as you have the right to impose other safety rules. Next slide. Now, the EEOC's guidance from 2020, which they update regularly, is good law. It was often mischaracterized in the press as saying the EEOC says vaccine mandates are lawful. The EEOC never said that. The EEOC said, if you want to impose a mandate without violating federal civil rights laws, here is how to do it. And they gave that roadmap last December, and that is still good law, and it is an easy to read set of FAQs that most of you will have taken a look at one point, and that were just updated on religious exemptions on Monday, and we'll talk about that later. Most of your state and local laws that protect disability or religion will be interpreted consistently with that guidance. So if you follow the EEOC guidance, it is a good faith basis for saying you are complying with your state and local law, unless there has been some interpretation otherwise. And the concerns about emergency use authorization have basically disappeared. We have final approvals for adults on 2 of them, and expected on J&J. And every court case that has come up so far where there have been challenges to mandates on various reasons, including involuntary medical experimentation or emergency use or other claims, have been dismissed. And so that the concerns about that have all but disappeared. Next slide. So one other caveat, as our friend Dan would tell us, is always a big caveat for labor relations issues. Your right to impose a vaccine mandate is on unionized employees is going to be subject to the any collective bargaining agreements, your management right clauses. It may be a mandatory subject bargaining, it may be an effects bargaining, but that will depend on your contract, your contact history, how your contracts are written. Next. So let's shift directly to the federal government contractor rule. Next slide, Mary. So the federal contractor rule, it is in effect. It is being rolled out already. This is the rule for the mandate, the hard mandate for all federal employees and for all federal contractors and all subcontractors on federal contracts. We are already seeing clauses that are being renegotiated, proposed changes. Many of you, or some of you may have already seen or had communications from the agencies that you contract with or prime contractors. The general principle is that federal contractors and subs are going to be treated the same as federal employees. That's because this rule is targeting service providers to the federal government, including all of those people who may work side by side or in federal facilities, but it's not limited to that. There are going to be new federal procurement rules. These are all being coordinated by OMB and actually being coordinated by the White House, which has a special task force just to implement this new rule. And these rules are going to apply across all agencies in all future contracts and may apply back to existing contracts. This is a hard vaccine mandate except for medical, disability, and religious issues. And there are also rules in there that aren't just related to the mandate. They're actually workplace safety rules for things like masking, distancing, cleaning. That's part of this rule as well, so that covered contractors are also going to have to follow other CDC workplace rules. In other words, this mandate incorporates CDC, some CDC workplace safety requirements and makes it part of your contract obligations. Next slide, Mary. So who's affected? It applies to all federal contractors and subs except, and these are the two big exceptions. One of them is for manufacturing of products. It doesn't, if all you do is make things that you sell to the federal government, this rule does not apply to you. If the prime is a small prime contract, less than $250,000, then it doesn't apply. But that's the prime contract. You may be an entity that is a subcontractor that only does $50,000 on a federal government contract. But if the prime is more than $250,000, you're going to be covered. We see this all the time in the construction industry. Even small construction contractors are going to be covered because the prime on the project is much larger. There is no minimum dollar threshold for the subcontracts, so it can be very small. But we're often asked about this. It does not apply to recipients of federal grants. Any kind of grants, federal financial assistance, money that is not a contract is not, the rule does not apply to that. Next slide, Mary. So the changes are already in effect. They are triggered in any contract awarded after November 14th, and with a very short time to get vaccinated. Many agencies are already notifying folks. It applies to new contracts. It includes, applies to any extensions, options, and the agency has, all of the agencies have the discretion to apply this retroactively. So you may get notice from an agency, even though you've got some time left on a contract, that they are doing a unilateral modification, which the contract probably almost certainly provides for, to add the vaccine mandate requirement. At this point, the best source of information on this is the various FAQs that are being updated by the White House. Next. So which employees are covered? This is the part that can get confusing. Let's just, we're just going to give you an overview of what you need to look at here. First, it applies to a covered contract employee. Basically, these are federal government contract terms. It can be either somebody who's working actually on a contract, They are billing to the contract. They are providing services that are billed directly or indirectly through the prime to a federal agency, or in connection with. And the in connection with language is used for all the administrative positions that support the contract in one way or the other. Large federal government contractors understand what this is because they are the indirect costs and the people working, doing marketing, finance, administration, other things. Those holding smaller federal contractors may only have a handful of people who are serving on the contract and not realize that HR and finance and legal and other people might also be covered because they work in connection. All of these employees must be vaccinated. Next slide. Then there's the ripple effect. The ripple effect is that once you identify that you have covered employees, everyone working at a workplace where those people work must be vaccinated, even if they have nothing to do with the contract. I may have 10 people in a 100-person office who are working on a federal government contract, but everybody in that 100-person office is going to have to be vaccinated unless they have an exemption, unless you can prove that they have no contact with anybody else. You have to basically isolate your contract employees from anybody else, which is not feasible. And if you control another location and somebody from your main office goes out there occasionally because that first person was covered at the main location, then other locations that you go to. This is why many federal contractors are moving in the direction of just applying uniform rules to everybody. Next slide. So who's exempt? Medical, disability, and religious exemptions under federal or state laws. And the executive order and the contract provisions do not define what these are. Basically, it's left to the discretion of the contractor to determine how they're going to apply their exemptions. Next. So how do you approach this rule? First, you got to know if you have contracts, and that may be easy in some workplaces and hard in many others. I'm familiar with higher ed institutions that are supposed to get all of their contracts reviewed through a central general counsel's office, but in fact, they don't do so, and not everybody sends them in. So you need to know what contracts you have. If it's subcontracts, figure out the prime, and then who works on them. And often HR, in a large organization that's billing, you know because you have timesheets that are being reported, but you may have somebody else on fixed fee or services contracts that are not going through HR, and you need to figure out who's covered. Next slide. If you don't want to go the role of a uniform mandate, you then have to figure out how you minimize the number of employees that you have to get vaccinated. And you can do that if they are isolated, and it might be feasible. And you could reduce people going between workplaces to reduce those that are covered. This is going to get fairly complicated. And we don't know what, and the enforcement is going to be left to the individual agencies who are overseeing your contract. So this could be a difficult process. Next. And even if you already have COVID vaccine policies, you need to decide what you need to do. One of them is going to be to provide vaccine documentation. You're going to have the proof of vaccination from your employees. You're going to need to be able to provide it to the prime or provide it to the federal government. And that means you need releases from those that you have the vaccination from, because that's confidential information. And then if you are not here yet, you're going to need to impose the mandate. Next slide. So I'm going to turn it over to Lisa now to talk about what we think might or might not be in the OSHA. Actually, before I do that, Lisa, anything else to add on what we've covered so far?
No, I think we're all set to keep moving along. Thanks so much, Rob.
All right.
Next slide, please. Okay, so we've had a lot of questions about what is in the new OSHA rule with respect to large employers. What we know so far is that the coverage is intended to apply to employers with 100 or more employees. And we expect that in terms of counting and tracking, it will probably mirror other federal laws that are already in place. When you think of the FMLA, EEO, and other similar rules, you're going to anticipate including your part-time employees, excluding independent contractors, things of that nature. An outstanding question is, will employees have the right to choose testing in lieu of vaccination? That's obviously the big question that we're waiting to receive guidance on right now. And again, as Rob said earlier, will the OSHA rule require that employers impose a hard mandate or a softer mandate with more flexibility? Next slide, please. So will medical and religious exemptions be needed? Unlike a hard mandate, if the OSHA rule simply just requires that all unvaccinated employees have to have weekly testing, then there's really no need to consider these exemption questions that we know that you're all wondering about, that we've been getting constantly, in terms of if someone raises a disability question or a question about religious accommodations. If you're simply going to enforce and allow weekly testing in lieu of the mandate, then you can just follow that protocol, which is a task in and of itself, of course, but you won't have to deal with as many hurdles regarding exemptions, because there's a much, much smaller population that require legitimate exemptions from the actual testing process. Next slide, please. So as we alluded to earlier, when it comes to the OSHA rule, what we're trying to clarify now and what we expect to have guidance on either literally, any day now, or certainly in the next few weeks, are the types of tests that are going to be required, the frequency, the cost, whether there's informed consent and confidentiality. I do want to highlight that paying attention to who bears the burden of the cost of the test is going to be critical as you assess the needs and capabilities of your business moving forward. Obviously, right now, most individuals have the ability to go to their local pharmacy or a lot of different testing sites and get a free test. However, in the future, when testing is being done simply as part of an employer mandate, as opposed to a health-related reason, there's a question as to who's going to bear the burden of those tests. So we're waiting on more guidance there. And of course, in terms of confidentiality, maintaining accurate records that are confidential as to the results of those tests is going to be critical as well. Next slide. We want to also highlight, sorry, Rob, is there anything you wanted to add on?
Yeah, before we move on, Lisa, let's just make clear, these are two separate rules and they are going to overlap. Whatever the OSHA rule comes out, 100+ employees is a different rule than those applying to federal government contractors. We don't know a whole lot of details. The OSHA rule is probably going to get challenged the minute it comes, nanoseconds after it comes out. That may take a while to shake out. But the OSHA rule is going to provide a roadmap and details on all of those issues we just covered. And we don't know the answers to most of those questions yet on who's defined. Just as there are still open questions to be determined with the federal government contractor rule. But one of the things we do know is that the definition of covered employee covers anybody who's working on a contract, even if that is a temp employee or somebody else. If they're billing to the contract, working on the contract, they are subject to that, as well as other subs. Thanks, Lisa.
Thanks, Rob. We want to jump into factors to when considering vaccine mandates for employees. So let's move right along. Next slide. We hope that at this point, a lot of you have either already issued a survey or you're in the process of issuing a survey to get more information about your workforce in terms of who's vaccinated, who's planning to get vaccinated. And if employees are not vaccinated, delving into a little bit about why that is and being, of course, cautious about those questions. We always want to be careful not to go down the road of asking questions where someone is going to provide information about a disability, because questions related to specific employees' disabilities could be prohibited or restricted by the Americans with Disabilities Act. However, simply asking employees if they're vaccinated, if they're planning to be vaccinated, questions of that nature are permitted. We strongly encourage them. There's a lot of third-party sites like SurveyMonkey and others that you can use to very easily administer these surveys. We do recommend that you make these surveys mandatory, as I'm sure you can imagine. If you simply say to employees, hey, when you get around to it, can you let us know your vaccination status? Or we would, really like some feedback. A lot of people, that's going to fall to the bottom of their inbox, right? So we want to encourage you to make these surveys mandatory and to get them issued and to analyze those results as soon as possible. And also, of course, understand that once you have information, and we'll continue to touch on this, once you have the information about an employee's vaccination status, that should be treated as confidential, and you need to be very careful about who has access to that information. Next slide. We have received a lot of questions, and I know there's been a lot of questions in the media about what incentives, and we'll talk even about penalties that employers can provide in order to encourage employees to be vaccinated. We generally recommend and encourage clients to consider incentives instead of penalties. They're a lot easier to administer in most cases, and you have a few different options there. Including, of course, providing additional time to get vaccinated, additional compensation, which, by the way, in a lot of cases you're required to provide anyway, but even, providing additional compensation maybe on top of what's required under the law, providing transportation or stipends, bonuses, all of that, you should be considering and discussing with your counsel to the extent that you're going to issue those incentives. There are some caveats, though. Of course, if you issue an incentive now, employees who got vaccinated 6 months ago are going to have a lot of questions about, well, why didn't I get X, Y, and Z, right? And so we need to think through, if the incentive is being issued now and it's different to what was issued previously, why is that? What's your cutoff point going to be? How is that going to impact morale? Should the incentives be retroactive? But we do encourage you to consider all the tools available to you in terms of incentives. Next slide. The flip side of that would be to enforce penalties, to say, okay, you've decided not to get vaccinated, but here's going to be the repercussion of that. And while it is technically permissible in certain circumstances, it's much more difficult to administrate, and it can be hard to penalize. We saw an example recently that came out, it was a couple months ago now, but Delta Airlines imposed a penalty of raising health insurance premiums for unvaccinated employees by $200 a month to cover the cost of COVID. This was done under the rule of being included as a quote unquote wellness plan under the Affordable Care Act. So there were some exceptions there, which made this type of penalty technically legally permissible, but there's a lot of moving components there in terms of the Affordable Care Act, ERISA, EEO compliance. And so you should understand that to the extent you intend to go the penalty route, there's a lot of moving pieces, and it's really important to make sure that you don't step over the line with respect to any of these complicated federal laws, not to mention state laws or other executive orders that might be in place that might impact those decisions. Next slide. Of course, throughout this whole process, you should be performing a cost-benefit analysis in terms of employee retention. Of course, the goal is to encourage vaccination and to understand your population, how much of the population is vaccinated, who's intending to be vaccinated, in terms of returning to work, remote work versus in-person work. And then what are the implications of a mandate, right? So if you have the option to continue to allow testing as opposed to a mandate, what is going to happen to your workforce if you impose a mandate? We know that the labor and the workforce and the culture and the environment right now is that there's a lot of you looking to hire, and employees have a lot of choices. Candidates have a lot of choices about where they want to work. And so in terms of considering employee retention, you should, think about the culture of your workplace, think about who can continue remote work, what are the costs and versus the downsides to imposing a mandate, perhaps on employees maybe who are working remotely versus those who are only performing in-person services. Next slide. And then, of course, when we get to actually requiring proof of vaccination, there's a couple of different routes that you can take. The first one would be just the honor system, just, saying to employees, our policy is if you're going to come to work in person, and especially if you're not going to wear a mask, you're doing so because you've been vaccinated, and we're going to take your word for that. Frankly, as you can imagine, there's a lot of risk there, and that leaves a lot of room for interpretation. And as much as we want to trust and rely on all of our great staff and employees, you could run into some hurdles there. If individuals become sick, if there's an issue about whether a person is actually vaccinated and perhaps was not being honest about that. So that system is hard to verify. You could require an attestation or certification that from the employee that they are vaccinated, that they're affirming that they've taken those steps. so that you're getting them to confirm in writing what they've done, which, the implication there is that they're not going to be, perjuring themselves and lying through this document. The most common mode I've seen of proof of vaccination is just receiving a copy of the vaccination card. Now, we know that there could be situations or concerns about fraud, employees providing fake vaccination cards or cards that have been modified. But in general, this is probably the easiest standard to at least start with, because you have an understanding of what the card would look like and what information you would need to see on that card. And then there are going to be some state and local localities throughout the country where you're going to have a system established by the government, an app or something like that, where you can easily verify who has actually been vaccinated. In terms of considering, fraud prevention, one option that you can have is to combine these methods, right? So have the actual copy of the vaccination card along with the attestation that the employee is certifying that they've been vaccinated. So you're, having both methods, and it's easier to discipline or take action if you come to find out that there has been an employee who's provided fraudulent information to the company. Next slide. Confidentiality. We've talked about this. We're going to continue to highlight it because it's really, really critical under federal and state employee protection laws. Vaccination status is confidential information. So while simply asking someone if they're vaccinated is not a disability related question, once you have the information that someone is vaccinated, that information needs to be treated in a confidential manner and can only be shared with individuals on a need to know basis. So it might be supervisors or other individuals who are imposing, for example, mask mandates or other safety protocol based on who is and is not vaccinated. But it's really critical that you have a clear policy in place as to who's privy to that sensitive and confidential information. Next slide. Rob, anything you want to touch on here?
Yeah, just add a couple of things on those slides and cover a couple of the questions. On confidentiality, for any of you who are going to be subject to a mandate, federal government contractor mandate, to provide that, I would start collecting that information now, but there's no need to turn it over until you are requested. That was one of the questions. There is nothing wrong in asking employees to waive their ADA confidentiality rights to enable you to share that information where required. There's a good argument that if your federal government contract requires you to turn over those vaccine cards to the federal agency or prime, you have a right to do that because federal laws, one can supersede the other. But I would just get the release, and you'll have other situations where you may need to share that with customers or other places that are requiring proof of vaccination. So you can legally ask for it. Now, if the employee won't consent to doing that, then you may have to limit where they can work. They may not be able to work on that contract if they don't allow you to go ahead and do that. And if you missed it, the HHS about a month ago came out with a very simple couple-page explanation as to why nearly everything that people think are covered by HIPAA is not. This is an ADA issue only for confidentiality. Thanks, Lisa.
Thanks, Rob. Next slide, please. Okay, so we're going to continue to highlight that there's many different pieces of the puzzle here, and we need to dot our I's and cross our T's when it comes to checking and coordinating with local laws and rules. We have obviously the federal law, executive orders, OSHA rules, and the federal level of guidance that we've been talking about. But then there's another layer, which is, does the state where the employee lives or works prohibit the employer from requiring a vaccine mandate? Currently, there are prohibitions in Montana and Texas in terms of private employer vaccine mandates, which are in various forms being challenged to some extent. And then there's many more areas that are prohibiting vaccine mandates for state employees only, as opposed to the private sector. And then we have states actually on the flip side, like New York, that are basically requiring people to provide proof of vaccination almost everywhere you go. So it really depends on where are your employees working. And as we'll talk about throughout the presentation, this includes remote employees, right? So if somebody is working from home or at a remote work site, what laws and rules apply to them as well. So be really mindful that there's multiple different layers in our checklist when we're thinking about implementing these policies, and what's permissible in one region might be different in another. Next slide. As part of this analysis, you need to determine which of your employees are going to be subject to the vaccine mandate. So we've seen some companies and clients that are mandating vaccination for everyone across the board, no matter where you work. And it's just for purposes of keeping things consistent, applying the same rules and processes to everyone, so that in the event you do have employees interact or overlap, you have the same processes in place. You know that everybody is vaccinated and you don't have to worry about having a second set of rules or encountering issues down the line. However, it's more common, and I think what we see more often is that we're going to focus on the vaccine mandate for employees who are actually reporting to work in person, or for people who are interacting with the public, or in healthcare services, obviously people interacting with patients. It's going to be very difficult for those individuals to demonstrate that they don't need to be vaccinated. And in most cases, that is already required, subject to the exemptions that we're going to discuss. So think about what portions of the population you're targeting and make sure that your policies are specific to those portions of the population. And as we say here, any policy that you roll out during COVID should have a caveat that this is your approach at this time that is subject to change. This is a moving target. We've seen many iterations of these rules come out. It's a developing issue, and you need to have that flexibility. Your employees need to understand that these rules are going to change over time. Next slide, please. So this whole concept of determining which employees are going to be covered by vaccine mandates certainly applies in the realm of in-person service providers. We already know that hospitals, nursing homes, and healthcare providers were among the first to be subject to these rules. There are a number of local laws we just want you to be aware of. To the extent that you have a contract, work with, or employ anybody in these positions, a lot of cities and states are requiring that people in these roles who perform these services are vaccinated. So even if you're a private entity and you have not enforced a vaccine mandate across the board, where the employee is working, if it's work for the government, they may require a vaccine mandate. So you should expect that we're going to see in most areas of the country, more and more of these vaccine mandates roll out across the board. Next slide. Okay, so when and how are you going to require vaccine mandates if you haven't already done so? You want to be clear in your policies that you're going to, first of all, you should provide advance notice, right, to give people time to get vaccinated if they haven't, or if they're in the process of getting vaccinated. You want to have that hard deadline, which of course you can always modify, but you want to give people a deadline to get vaccinated. You want to describe the process of requesting an accommodation, who that request should be sent to, and where they can find information about what is needed to be provided as part of that request. This is not a situation where an employee is saying, I have a disability or my religion prevents me from getting vaccinated is enough. We assume that most of you are aware of that, but that is not where the buck does not stop there. It's a much more involved inquiry, and employees need to be aware of that from the get-go. We also want you to be aware that, of course, there's a lot of information out about boosters right now, and more boosters are going to be coming available in the near future. Do not worry about boosters right now in terms of your vaccine mandate policy. You do not need to require at this point that employees have their vaccine plus a booster in order to return to work. We're going to get more guidance about boosters down the line, but you don't need to incorporate that in your policies right now. Next slide. Okay, third-party rules. We have also received a lot of questions about this. If you are an entity that has a lot of third parties, contractors, vendors coming to your site, and your question is, okay, we're requiring vaccine mandates for our employees. We have very strict safety policies. What about all these other people coming into our facility? Well, absent a state or local law that restricts you from putting in place a vaccine mandate, you can require vaccination as a condition of being permitted onto your facility. There are going to be questions about what that proof looks like and where you're getting proof or confirmation from those individuals. But as a rule, you can require that employees who are coming, or I'm sorry, third parties, vendors, contractors coming to your site, visitors, you can require vaccine mandates across the board. Next slide. And Rob, I didn't know if you wanted to add anything after that section.
Thank you, Lisa. Now I'm going to tell everybody to take a big, deep breath. And let me just pause here and say, vaccine mandates and what you're going to have to do with them They're going to come in all shapes and sizes. If you are a federal government contractor or a sub, you're going to have to sort out what's required and what's not on those particular contracts under those rules. If you have 100+ employees, you're going to have to sort out the OSHA requirements. If you are a higher ed institution in a state like Illinois that is requiring vaccine mandates under a state executive order, you have to sort out what's covered and what's not there. If you are a healthcare provider under the Medicare HHS rules that were issued several months ago, it's a separate set of rules. If you are a provider of services to a city like Philadelphia that requires contractors, it's a different set of rules and requirements. There are some general principles, and if you're not covered by any of those, or even if you are and sorting things out, you can impose your mandate on your own broader than the minimum number of employees who are covered. So you have a lot of things to sort out depending on your size and the nature of your workforce, and whether you want to just do a hard mandate for everybody absent the exemptions. So this is not a one size fits all. One of the questions we got was, I have a franchisor requiring its franchisees to get vaccine mandates. That's going to be purely a question of the franchise agreement and whether or not they have the power to do that or not. And that's not related to any of these other laws. So let's spend just a couple minutes on testing, because under at least the OSHA rule possibly, and under others, there are sometimes options to do weekly testing, or you may choose on your own, if you can, to say, I want to do testing rather than a hard mandate, because otherwise I'll lose too many people. So let's talk about some practical issues. Next slide, Mary. If everybody I know who's already looked at this has said, this is going to be a big pain if I have to do weekly testing, particularly in those areas, some industries, some employers that may have upwards of 20, 30% or more of their employees who are still unvaccinated. OSHA rules may give us a lot of details on this, or they may not. We don't know how specific they will get. But any testing program that you choose to do needs to think about the types of tests, when, where, how, whether people get paid, who pays for the cost of the test. Next slide, Mary. So as a general rule, under the FLSA, it is likely, and there's been no specific DOL guidance on this yet that we've seen, that you're going to have to pay hourly non-exempt employees for the time they spend getting testing. There are similar and analogous rules for other kinds of medical tests that are required as a condition of employment. Again, we don't have specific DOL guidance on this, but there's some fairly extensive past guidance you and your lawyers need to look at. It is possible, and there is buried in the DOL, a de minimis exception for tasks that take less than 10 minutes. Next slide then. And that could apply to the rapid tests. Who pays? Well, these are still free as a general rule when they're taken, but it's unclear whether it's going to remain so or whether there are co-pays or other issues. The only thing we have so far is the OSHA rule for in healthcare that said that there could not be any cost to the employees. That's for the cost itself. There's also language in the EEOC guidance that alternatives to such as testing to alternative accommodations or alternative methods to accommodate somebody's disability or religious exemptions. You know the old rule, you can't have employees pay for accommodations. So if the testing is the alternative to their exemption, you may need to pay for it under the EEOC guidance. Next slide, Mary. Which tests? Look, rapid tests and antigen tests, easiest, cheapest, but then you have to figure out how to verify it. And are you going to do it at the workplace? Are you going to have employees do it at home? Do you trust them not to lie? Do you want to do video verification, watching them take the test? There are rapid tests available from healthcare providers that are more reliable and more expensive. And of course, the PCR tests, you're going to have to wait for results. I was talking about this with a physician friend, a colleague of mine, on what it could mean if millions of employees suddenly need to be tested weekly and the demand for that, and how long the labs are going to be burdened. And he said, well, I think you should have the tests administered on Wednesdays in order to be ready for work on Monday. I said, why? Well, that's our lightest day for most healthcare providers midweek, but you're going to have to, it's going to get complicated. Next slide. When and where to test? We just covered this. At work rapid tests, one possibility, but can you see everybody standing in line waiting for their rapid test results in the morning, sitting around and sending the others home? Can you really accommodate that in your workforce? Next slide. So you are allowed to do these tests under the ADA as job-related and consistent with business necessity. But this is one of those places where the EEOC guidance in its FAQs on testing actually cross-referenced the CDC rules on informed consent, which takes in the whole question of disclosures to employees on the test, the consequences, the accuracy, and what's going to happen. And you need to treat the test results as confidential, and you need to figure out what to do with the tests, the test strips if you're doing them on site, or the test kits. Now you've got medical waste, which implicates EPA rules potentially on medical waste that you have in the workplace. So it is complicated. Next slide. And then if you do more testing, you're going to have more positive results. You're going to have to do contact tracing. You're going to have to isolate people and follow the CDC guidance on that. Next. So it's just difficult. So what about other requirements? Next slide, Mary. As a general rule, under OSHA may say that you have to, as a general rule, the unvaccinated are not a protected class, except in Montana right now. And as a result, you can impose other requirements. The EEOC is clear about this, is that even if somebody is unvaccinated, you can impose other requirements on them. Remember, when the rest of us were allowed to take our masks off, EEOC would have said it is perfectly fine to require the unvaccinated, pursuant to CDC guidance, to continue wearing masks in the workplace when others people don't. Next slide. So common requirements on the unvaccinated, or including but not limited to those who are under exemptions: masking, social distancing, or even excluding them from the office, excluding them from in-person events, excluding them from any events where food and drinks, where masks are going to be off. All of those are legitimate safety rules to protect both the unvaccinated people and others from transmission and from breakthrough infections for our vaccinated employees. Next. So now the fun topic of disability religious exemptions. Next slide, Mary. The disability, we tend to lump all these together, but all the principles for these exemptions are basically ADA and Title VII religious and disability accommodation issues. All of you are familiar from the past with making accommodations for employees with disabilities, for making religious accommodations, or a process for employees seeking exemptions or anything, time off for religious purposes. Follow those procedures. The principles of this are no different, and the EEOC is citing back to its other guidance in all, under the ADA and Title VII. Now you're just applying it to something different. So one of them is disability exemptions. In fact, and this is really anybody with an ADA covered disability, which is a pretty broad definition. But the CDC has recommended the vaccine to almost everybody. The list of people for whom the CDC does not recommend the vaccination is very, very small, primarily those with severe allergic reactions. They say that everybody else can and should get it. Next slide. But you will have some people who need deferrals because they've just had COVID. And the CDC now recommends pregnant women get the vaccine, but that's different. So most of the medical exemptions you get, most of the employees who say, I don't want to get the vaccine because of, or I can't get the vaccine because of this medical condition, it's not going to be contrary to CDC guidance. They should, but they may have a doctor that writes them a note. So here's the question: what's your tolerance on the notes that you get? Are you going to want to go contrary to the doctor's recommendation, or rather do you want to say, okay, I'll accept this conditionally at this time, and I'm going to revisit this in 60 or 90 days. And that's one way to deal with the exemption right now, because you can go back and look at it again later. The EEOC clarified that in its brand new guidance. Next slide. So other medical requests, we think you can ask the doctors to say which CDC principle applies. And when you ask that question, they will typically, drop their entire request, because it's not contrary to CDC recommendations. But you'll have to decide internally your tolerance for complaints or claims later, and whether or not you want to push back on doctors' notes you receive or just grant the medical exemption. Next slide. Now into the religious issues. I think everybody's familiar with the fact that we are getting inundated with religious exemptions. EEOC principles are basically going to be the same as those under state and local laws. There is a lot of law on this, and the EEOC just provided some additional technical assistance earlier this week. Next slide, Mary. So the two-step process, and by the way, this is your first CLE code. Look at that there. If you're seeking CLE, your code number is 13572. I repeat, 13572. Now, two-step process. Think about it this way. Is this request based on a sincerely held religious belief? If it isn't, it can be denied, period. The second step, if it either is a sincere religious belief or you don't want to argue about that right now, can the exemption be accommodated? In other words, what are the alternatives? Is remote work possible? Can I keep people separate? Is masking and weekly testing sufficient to minimize the risk in my workplace? Or am I going to take the position that because of the nature of the work, I can't accommodate somebody without posing a more than de minimis burden and elevated safety risk on coworkers or customers, and therefore I'm going to terminate this employee or take other adverse action? But these are two separate steps. Next. So religion, very, very broad. When you look back at the EEOC technical guidance from Monday, it really just parrots what's in their case processing manual. And that is to say, traditional principles are that Title VII religious protections are very broad. It can apply to religions you've never heard of. It can apply to small groups of people that believe something that's different than the denomination or sect or faith that they profess to be a part of. It can be a small group of people only that have something completely illogical or unreasonable to most people, but that is what they believe. If it is religious or spiritual and based on a belief in a higher power, it is religious. And you can't just be skeptical and say, I've never heard of this, or this is not a mainstream religion. Next. However, this is the one we're dealing with now. Social, political, economic, personal preferences. These are not religious beliefs. Religious belief has to be spiritual. It can't just be anti-vaccination. The EEOC's technical assistance gives some examples of this. Just one of the specific languages that's going to be very, very helpful to us on this is that concerns about the safety and efficacy of the vaccine, or feeling that I don't need it because I'm a healthy young person or I've had COVID before. Those are personal preferences. Those are health and safety issues. Those are not religious beliefs, no matter how much it's been cluttered with religious language and citations to the Hebrew Bible and the New Testament. No matter how many quotes there are in there, they are still based on safety or efficacy or personal liberty and freedom. Those are not religious beliefs. Next slide. So here are some of the examples. If you see constitutional claims, liberty issues, if you see complaints about involuntary testing, or I don't need it, and a lot of these objections are based on misinformation, false information about the vaccines themselves or their efficacy. Those are not religious, and you can deny under step one on that. Next slide. This is the same. This is basically the slide. You can go back to it later, is whether it's really the same belief system as others. Next slide. So here's the question: how far can I push back? Under the new technical assistance, more than you may feel comfortable doing. A lot of employers are uncomfortable challenging religious beliefs, but you can. If you have an objective basis, you can do so. We're finding and hearing anecdotally that if you have the time, interviewing somebody about their objections, most people are going to dig a big hole for themselves and reveal that this is in fact an anti-vaccine or just an anti-COVID belief rather than based on a religious belief. But more often people are requesting supplemental statements on that. You can question when you have an objective basis. Next slide. And a lot of the pushback that people are doing and that we are advising you can legally do is whether this is a consistently held sincere belief, whether or not they have made similar objections in the past, whether or not they've ever given vaccinations to their kids or objected in the past. For many of these claims, you'll find that this is the first time the individual has ever refused medical treatment for a particular reason. But one of your alternatives when you're sitting there with 200 of these requests is to say, okay, we're going to accept this at this time, and we reserve the right to push back later, and then move on to the next step of undue hardship. The last step, next slide, please. And the last step, oh, here's some of the possible questions. You can go back and look at this. Have you had prior vaccinations? Have they had other treatments that are considered invasive? Have they ever investigated in the past or in the future the use of fetal stem cells and the development and testing of all the drugs that are on their shelves? The answer usually is going to be no. Next slide. Then you have to think about alternatives. And before you can fire somebody, if you get the exemption, you have to go through what's the burden of doing the alternatives or allowing that person in the workplace if you decide to accept it at this time. Next slide. This is where the EEOC guidance this week is helpful to us. Some very good language on undue hardship based on health and safety issues and the ability to weigh health and safety concerns as a factor, and ultimately to exclude somebody from the workplace if other alternatives aren't available, such as remote work. Next slide. So you have to go through the process, however, of saying, can this person do remote work? What's their risk? Are they customer facing or are they on their own? How many other people are vaccinated? How many other people in the workplace are not vaccinated? All of those you need to be able to do. And at the end of the day, if you're going to say, no, I can't accommodate somebody, you just have to be able to defend that conclusion as to why they're an elevated risk. Next slide. And just note, just the fears of everybody else in the workplace are not enough. Prejudice against somebody who has a religious exemption or disability is not enough. You have to base it on objectively on the safety risks or on the other burdens. Next slide. That's it. And my apologies to my next presenters for going 5 minutes over. Thank you all very much.